This video is to give you some context for understanding the concept of general jurisdiction and personal jurisdiction. There are two basic forms of personal in personam jurisdiction, and we discussed these when we put together our PJ framework. There are general jurisdiction and specific jurisdiction. We spent most of our time talking about specific jurisdiction. And so let's talk a little bit about how general jurisdiction is different from specific jurisdiction. Well, first, the assertion of general jurisdiction requires the defendant to have greater contacts with the forum state, and typically what we're talking about is more in number, a lot of contacts with the forum. Additionally, general jurisdiction provides the opportunity for the defendant to be subject to personal jurisdiction on any claim. That means, unlike specific jurisdiction, there's no requirement that the claim or your cause of action relate to the contacts in the forum. And so this allows you to bring a great multitude of different types of claims against the defendant in this particular forum because their contacts are so significant, there's so many, that it doesn't matter that there's not a relationship between the claim and the contacts. Of course, you could still assert general jurisdiction and have the claim relate to the contacts. It's just that it's not required. So in other words, for example, you generally find general jurisdiction over an individual defendant in the state in which he's a domiciliary of. So if you're domiciled in Ohio, you could be sued on any matter in the courts of Ohio because they could exercise PJ over you since you're a domiciliary of Ohio. That means that the claims could be unrelated to your contacts in the state of Ohio. They could also be related. You might have had an accident within the confines of Ohio and people bring a claim against you in the Ohio courts for that claim. It's just that in Ohio, since you have general jurisdiction over this potential defendant, you don't need to find such a relationship. All right, if you remember our international shoe guideposts and the framework we put together from the court's opinion, we were talking about specific PJ, which if you look in your boxes over here is when there is relationship between the claim, and it's generally when there's very few single or isolated contacts in the forum. You can exercise specific PJ. If you think about it, you're specifically going in and rendering jurisdiction over the defendant for this specific matter, for this specific claim, given his specific contacts with the forum. For general PJ, you say we're going to generally allow any claim to come in against this defendant because his contacts, as you see in the chart, are so significant. Even though they're not related to the case or don't have to be related, we're going to allow general PJ. All right, here's a multiple choice question. We're going to read it through, pause the video for a second, decide what you think the answer is, and then restart it so that you can hear the explanation. Which of these following statements is false? A, in practice, litigants assert general jurisdiction far less often than specific. B, general jurisdiction assures that there's always one place where the defendant is subject to jurisdiction. C, an individual is subject to general jurisdiction in the state of her domicile. D, a corporation is subject to general jurisdiction in the state of its formal incorporation and in the state of its principal place of business. Or E, it's always unconstitutional for a state to assert general jurisdiction over a non-resident individual or corporation. So pause, answer the question, and then restart the video. The correct answer is E. This statement is false. The biggest problem with the statement is the word always. While it's often very hard to meet the constitutionality test in international shoe when you have a non-resident individual or corporation and you're trying to assert general jurisdiction over them, it's not impossible. In fact, this is exactly what the cases for our reading today are trying to do. The other ones are true, so let's consider them for a moment. In practice, it is true that litigants by far assert specific PJ more often than general jurisdiction when PJ is really at issue. Of course, if you sue in someone's domicile or sue in the principal place of business or place of incorporation, it just becomes a non-issue because there is general jurisdiction there. General jurisdiction assures that there's always at least one place where a defendant is subject to jurisdiction. We consider this to be fair. If you think about the individual again, whose domicile will be the place where they're subject to general jurisdiction, they're an insider in that forum. They live there, and so it's not unfair for purposes of travel to make them go to the courts within their own state. They're also a political insider. If they feel like the laws or the forum itself is somehow unfair, they can vote about in that state and alter things. So we've talked about B, C, we talked about D. A corporation is subject to general jurisdiction in the state of its formal incorporation and in the state of its principal place of business. So those are the places you typically find, both C and D, places where you have that one forum that is subject for that defendant, where they're subject to general jurisdiction. All right, one of the first cases we see from the Supreme Court dealing with general jurisdiction is the case of Perkins. And this is discussed a little bit in your Goodyear case, and I wanted to give you some more context for what happened in Perkins. In Perkins, you had a Philippine company that fled the Philippines when Japan occupied the islands. They set up their sole office in Ohio, their general manager lived in Ohio, all their files were kept in Ohio. The directors had all their meetings in Ohio. They distributed salary, had all their correspondence in Ohio and from Ohio. They were headquartered there essentially because of the war in the Philippine Islands. And so I listed out 6 of the different things that they did, all in Ohio. While they still had a big piece of their business, the mining, the actual mining of the mining company was still occurring in the Philippines, their headquarters had to be moved since the islands were being occupied by a foreign invader. And the court said, for all intents and purposes, the principal place of business has essentially become that of Ohio. And so general jurisdiction over this foreign company in Ohio, it's a non-resident foreign company, was appropriate under the international sue test because they've been carrying on in Ohio in a continuous and systematic but limited way, part of its general business. The limitation again, they're still mining elsewhere. The mines weren't in Ohio, but the entire business was in Ohio. All right, the other case that's discussed in Goodyear, a Supreme Court opinion, is called Helicopteros. In this case, you had survivors and relatives of deceased workers who were killed or injured in a helicopter crash in Peru, suing various individuals who put together the helicopter and its parts and trained the helicopter pilots. So you have 3 different defendants, WSH, Bell, and then Helico. The only company contesting personal jurisdiction was Helico, and there's some interesting things about this case, why it came out the way it did, and other things that if they'd changed the litigation strategy might have operated differently. So first of all, what is the big fight here? Why is this before the Supreme Court with this one defendant on general jurisdiction? Well, in part it's because the plaintiff at trial had won a verdict of $1 million against Helico, but they lost against the other defendants. And so the only case that they had any actual enforceable judgment on was the one against Helico. And so now before the Supreme Court, Helico wins, which means the judgment was invalid against Helico since the court lacked personal jurisdiction over Helico. And that means that the plaintiff's options at this point are pretty limited. All they could do now is file suit against Helico in Colombia, where Helico was incorporated, or in Peru, where the plane crash occurred, and neither of those were all that enticing to the plaintiffs. So it's a big deal to have PJ over Helico in Texas, because if you have that, then you can enforce that nice $1 million judgment. If you don't, you can't, and we know ultimately they couldn't. All right. In the Helico, one other thing that's important to note is that the parties did not raise the question of whether personal jurisdiction on a specific jurisdiction basis for Helico in Texas would have been possible. Brennan notes that that could have been raised but was conceded by the parties, and so therefore the court doesn't consider specific jurisdiction and whether or not it's applicable as to Helico. And I wanted to note that because when you look at the contacts they had, one could argue that there was a relationship between these contacts and the claim and could have potentially achieved specific jurisdiction over Helico in Texas. But because of a practical I think, tactical error on the part of the plaintiffs in conceding that there was no specific PJ and limiting their arguments only to general jurisdiction. They fail. So make sure when you think about this as a practice pointer that you consider arguments in the alternative. General jurisdiction allows you to sue for anything, even unrelated things, but don't forget you can also argue potentially that these contacts related to the cause of action and that specific jurisdiction would have been appropriate. All right, so the big issue here is Helico a citizen of Texas? Answer is no, they're not incorporated or principal place of business there. Well, how do they stack up against the factors in Perkins? Do we find the president or general manager in Texas? Are the corporate governance meetings happening in Texas? Do they keep their records, correspondence, or have their salaries paid from Texas? Are there agents or employees in Texas? Do they have offices in Texas? Are they running their business out of Texas? Really, is this like Perkins? And the answer is no. None of those facts that were found present in Perkins are present in Helicopteros. So the question for the court in Helicopteros is, can general jurisdiction exist with less contacts than those seen in Perkins? And the court tells us under the facts of Helicopteros there wasn't general jurisdiction. So here are the contacts that were present in Texas. And the court systematically goes through these and discusses why it's insufficient. The first is that the CEO traveled to Texas and negotiated a contract with a Texas company. Again, we're not talking about specific PJ, so we have to look at the contacts themselves and see if they're of sufficient nature, significant enough that enough of them to render general jurisdiction over this defendant for any matter. And while you could have argued potentially this related to the cause of action, they weren't arguing specific PJ, and one visit is certainly not enough to constitute continuous and systematic. Compare that to Perkins. Perkins, the president, was living there, was operating all their meetings out of there. Just going for one visit on a contract is not going to be enough. The second contact was that there was payments from the Texas companies received in New York and drawn on a Texas bank by the Texas company. And so the argument here is that since Helico is getting paid by checks from Texas companies and getting the money from Texas banks, that somehow that's a contact. Well, the court here says that's not even a contact because it's unilateral activity of another person, specifically the entity that's the drawer of these checks, and that is like Worldwide Volkswagen. Someone else's activity cannot count as contact of yours. And that makes sense. Can Helico control where the checks are drawn, which bank they're drawn upon? No. You get a check from someone else, it draws from their own account, so you have no control over that. Thirdly was a bit more tricky for the court. You've got from 1970 to 1977 about $4 million in purchasing of helicopters and their parts and component pieces from Texas. And their training, number 4, they sent their pilots and maintenance crews to train at Bell in Texas. And here the court said these purchases, which are not insubstantial, are still not enough. They said mere purchases, even occurring at regular intervals, are not enough to warrant a state's assertion of personal jurisdiction over a non-resident corporation when the cause of action doesn't relate at all to those purchases. Again, they missed the opportunity to say, yes, it does relate. They're not arguing specific jurisdiction. So this even substantial purchase in the amount of $4 million over several years is not going to be enough. Same with the training. So, what Helicopteros doesn't answer for us is a lot of things. There's a lot of tough calls about what can happen in a forum by non-resident defendant and whether or not it can rise to the level of general jurisdiction. That issue of if you're not at Perkins, what else besides Perkins might constitute general jurisdiction? Is anything besides Perkins enough to constitute general jurisdiction? And so the questions that were open, some of which we're going to see come up in Goodyear, are the following. If you've got years of high volume of sales, it's more purposeful than just a purchase from a forum. Is that going to be sufficient enough? What if you had a small office and a few employees in the forum that continue to run a small piece of your business? Is that enough? What about a major component in the forum but not your headquarters, so a big branch office? Or extensive transactions over the internet with forum residents? Or individuals? How do these kinds of tests apply to individuals? Anything beyond their domicile, would that constitute enough for general jurisdiction? All right, and so just consider these questions when you read Goodyear and think about what is still remaining open that the court hasn't addressed. What is still unknown about what kind of contacts you might have and whether or not you have general jurisdiction.